This is the final case of our April case call, and I need the right name of your case. Well, you know what it is. Schaumann-Beltran versus, you tell me how to pronounce the doctor's name. Mr. Gonzato, if you're ready, it's a 15-minute mini oral argument on the application. You know how that works. You can try and reserve time.
Thank you. I'm Mark Gonzato on behalf of the plaintiff appellant in this case. This case presents a relatively narrow question involving the appropriate interpretation of 2.311A. The circuit court in this case allowed for the videotaping of a neuropsychological examination. The Court of Appeals reversed that ruling. And by the way, if you have any questions, you can ask questions anytime you want. I don't mean to stop you. The Court of Appeals ruled that that portion of the circuit court's order was incorrect, and it did so largely on the ground that the videotaping is not mentioned in 2.311. That ruling was erroneous, largely because the rule itself does in fact, it doesn't give discretion, it actually mandates that the court in ordering such an examination shall fix a number of things, including the time, place, manner, and conditions under which they will take such a examination will take place. What's also important about this case is that the trial court did in fact set a number of conditions for this neuropsychological examination. It had to end by 5 o'clock. It had to include snack and lunch breaks. And bathroom breaks as well. These are conditions which, if you followed through on the Court of Appeals logic as to how this particular provision is to be interpreted, sort of wouldn't be allowed under the Court of Appeals rationale, which is it had to be mentioned, videotaping had to be mentioned. Obviously, the Court of Appeals was first wrong in suggesting that videotaping had to be mentioned when the rule itself does in fact establish that there can be and has to be rules set as to the manners and conditions. I've pointed out the fact that the defendant in filing their motion to get the neuropsychological examination did in fact identify the plaintiff's position as imposing inappropriate conditions on this particular examination. So the defendants in their own motion, which led to this dispute, identified plaintiff's insistence on having, at that time, the parents attend the examination or be in the next room, that was some sort of condition that they were opposed to. So the defendant's own motion identified it as such. The Court of Appeals seemed to rely on two cases, neither of which was pertinent here. First of all, the Neems case, which is a relatively old Court of Appeals case. It's not even a case that under the Michigan court rules.
Can I just jump in? I'll try to keep my voice up. What rule would you have us adopt?
I'm sorry?
What rule would you have us adopt here? The rule for videotaping, what rule would you have us adopt?
What rule? I'm sorry.
Would you have us adopt?
Oh, what rule? The rule is that, first of all, this is a published decision of the Court of Appeals. And the Court of Appeals has gotten this court rule completely incorrect. The rule to be adopted.
Let me speak up again. Assume I agree with you. What rule should we adopt?
The rule you should
Are you
adopt,
asking us to follow the federal interpretation of their rule, which says as a general rule, these things shouldn't be allowed unless there's good cause to allow recording? Is that the rule you're asking us to adopt?
Good cause is already in this rule. You have to file a motion and there has to be good cause for them to get it. The question turned on its head is, do you have to have good cause to have this condition imposed? That's not in the court rule, though at least the way I read it. The fact is that what you have is an argument made by the defense in this case, and the Court of Appeals went in a different direction, and the different direction that they went is something that this court, in my opinion, has to correct.
But if we say it's allowed, we have to give some indication. Is it always allowed? Just so somebody walks by and says, I want a recording, so the court has to say okay? Or is it, when should the trial court allow it?
No, I'm not suggesting that it has to, or you're talking about the videotaping. Does it always have to be allowed? No, it does not always have to be allowed.
So how will the
question
trial
is
court, how will the court know when to allow it and when not to allow it?
Well, I should think it's going to have to be on the basis of submissions made to the court as to the importance of it and the effect it would have. The defendants have always insisted that this type of videotaping is somehow going to interfere with the results of the neuropsychological testing. That's been their position. That's not the position the Court of Appeals took in this case. So you're asking questions, Justice Viviano, about something that the Court of Appeals did not decide in this case. What the Court of Appeals decided is if it's not in 2.311A, it can't be imposed. And that's a ruling that can't stand.
I don't want to deal with this case twice, right? So if we're going to reverse the Court of Appeals, I think we're going to have to give some indication as to what we think the rule should be. I'm sort of, partial, I think, to the Sixth Circuit's interpretation. Federal courts generally do not allow a third party to be present during an IME or to have an IME recorded unless the party has established a special need or good cause from the Mager case. Is that the rule you're asking us to adopt?
Well, that's not the rule I'm necessarily asking you to adopt, but again, it's not the ruling of the Court of Appeals in this case. Now, there are cases, the federal courts have been a little less or more restrictive, let me say, in terms of this videotaping. The state courts, and there's the MAJ brief that's been submitted, which goes into a few of these cases from around the country in the state courts, have been a little more lenient, if you will, in allowing this type of videotaping of these examinations. But the fact is we have a decision of the Court of Appeals that basically guts the discretion that a trial court would have.
I know, I'm advancing past that. Assume that we agree that the trial court should have some discretion to do this. All these state courts that you're citing to, they all have a bunch of different factors for the court to consider. Like the Kentucky Supreme Court says that, if I didn't lose my spot here, the nature of the proposed presence, i.e. the presence of an attorney, will it be disruptive to the examination, et cetera. Evidence that the requested examination might be conducted in an unfair manner, such as past abuses, or the nature of the examination itself. Like in this situation, there seems to be a pretty strong indication that the type of exam here, allowing videotaping, might interfere with the ability of the examiner to objectively evaluate the plaintiff. Are those things that the court should consider?
Well, if the court is willing to reach out to address an issue that was not addressed by the Court of Appeals and has not been addressed, I will tell you, in my brief to this court, there was some discussion in the Court of Appeals. But
well, I guess this isn't a gigantic case. Are you suggesting that we should reverse them just on the issue of them saying they don't have discretion and then send it back and let the courts all work out what to do next and risk it coming back to this court on how they exercise their discretion and whether they followed the appropriate analysis? Is that what you're asking us to do?
Well, the question that's been posed in the order granting this oral argument addresses what the Court of Appeals did wrong in interpreting 2.311A. That's the issue. And I do not think, and we might be in agreement on this, that you can allow this decision on 2.311A to stand.
No, I understand it. Sometimes I try to get to the finish line too quickly, but here it seems to me if we're going to say what the wrong interpretation is, at the same time we might as well say what the right interpretation is.
Well, it would be something I would really like to have an input in, if that's what this court is going to be doing.
You're not invited back on that question. That's why I'm asking you now.
But Mr. Gonzato, if we agree with you and say that the Court of Appeals holding in their analysis of 2.311 was in error, whether we provide further guidance of what it should have considered, what's your position on whether or not, I believe the defendant also has an argument about that this particular type of an exam should be evaluated under, like they sought a protective order. And so the Court of Appeals didn't really address that because they jumped to 2.311. So would you agree at a minimum that the Court of Appeals needs to, if we disagree with their opinion here, that it needs to go back for them to address the other argument?
Yes, that is in fact what has to happen, it seems to me, in light of the fact that you are correct. They did not address the principal argument that the defendant raised in the circuit court and the Court of Appeals. They were not addressed.
Okay.
Mr. Granzato, what are we to make of the neuropsychologist, amici? They filed a brief, I believe, saying that they have ethical concerns. Obviously, we as attorneys we take our ethics very seriously. I'm not doubting they do as well. How do we square that?
You know, in thinking about this case, what strikes me, and that you are correct, that was in fact raised by Dr. Huffman. If you think about how often we are on camera without knowing it, as we live our daily lives, and how unobtrusive, ask the ACLU if you would, okay, how unobtrusive videotaping has become. Why? I don't quite understand how we could be getting into an area where that even not only disrupts, but disrupts the actual testing, but even becomes something that crosses some sort of ethical line. It doesn't seem possible to me that you can make so much out of this when we are on video all the time. I'm on video right now, right? The fact is that it's everywhere. And I don't know, I guess maybe it does, it's supposed to deter some amount of behavior, change some amount of behavior, but how often do we think about it? And why would this not be unobtrusive? Why would this not be? You know, when I worked in this case in the Court of Appeals, there was some indication in even the literature that they presented that cast a little bit of doubt. I won't say a great deal of doubt, but a little bit of doubt on this and on this question. But an ethical consideration that this Dr. Huffman will not participate in this because of a camera, which who knows how it would be filmed.
But it's not just the doctor, it's the doctor and the association, right? The national, the national association. It's not just one doctor saying, I won't do this.
Yes.
It's the doctor backed up by so, I mean, to me, the judge has to balance these things and make the determination you're suggesting, whether that's a valid consideration or not, with all due respect. Though I think the judge is going to have to hear from the people who do this work, not lawyers, on how to do that work, right?
Yes. There is one thing I want to, if I can, and I want to stress from the Feld case. And that's the case that the Court of Appeals, I think, erroneously relied on for the expressio unius. But there was one observation in the Feld case that I would like to leave this court with, and that is Justice Boyle's concurring opinion in the case, because she led off that opinion with what I think is a very important thing to remember about this. The Feld case involved workers' compensation in a particular statute that allowed a doctor, as opposed to a lawyer in the examination. Okay, but what Justice Boyle said as she began her opinion in Feld was, it would be naive not to recognize the inherently adversarial nature of a physical examination requested by an employer. And on behalf of every plaintiff's lawyer, it would be naive. It would be naive for any plaintiff's lawyer to treat this type of examination as anything other than an adversarial process. It's true. And the fact is that this doctor is going to interview the patient, the plaintiff in this case. The doctor will be able to talk about what the substance of that interview, and the principal question this case presents to me is, why can't this interview be subject to something that's not up to the doctor's notes later on? With that, if there are any questions, and I apologize for my hearing loss.
I apologize for not speaking up. I never do. I mumble.
Good afternoon. May it please the court, Aaron Beach on behalf of the defendants. I'm sensing where the court might be going on the legal merits of what the Court of Appeals did, so I'm going to rest on my briefing for the notion that a condition of an exam.
I don't want to interrupt, but I don't mean to ward you off. You can make your argument on the interpretation. It does say condition. The court doesn't seem to have really focused on that. And I looked at the federal courts, what they've said on this, and it seems like this could be a condition, but if you have a strong argument otherwise.
I'll just make two brief points, both of which are in my brief, so I won't belabor them. The first is that the request for video recording was treated as a substitute for attorney attendance, which is in the Michigan court rule, is not in the federal court rule. And so that's my explanation for why the federal rules call video recording a condition of the examination under Federal Rule 35A, while the Michigan court rule, as interpreted by the Court of Appeals, because it allows for attorney attendance, that's already kind of taken care of the attorney observation portion of it, for which video recording was sought to be substituted in this case. So that, to me, is the relevant difference. And it's the reason why the Court of Appeals ruling makes sense once you look at that specific context for video recording, rather than the face value argument that plaintiff is making is that, well, a condition is a condition. It's anything under the sun. It could be that, she's got to wear a certain kind of shoes or no perfume or things like that. It wasn't treated as a condition in this case. It was treated as a substitute for attorney attendance. On the inherently adversarial nature of a defense medical examination, this court rejected the presumption that IMEs are inherently adversarial, and they did that in Feld in the majority opinion. The Feld majority held that a lawyer's presence would inject a partisan character into what should otherwise be an objective inquiry. So while Justice Boyle and the three justices in the dissent did buy into that inherently adversarial nature argument, the majority opinion didn't reflect that. And this court then rejected that presumption again in Mucci versus State Farm, which is a 2012 case, where they said that if you're going to argue that there's good cause for a recording based on a physician being, and this is their words, the adversarial agents of the insurer, then that requires particular and specific demonstration of fact as distinguished from stereotyped and conclusory statements. And I think that all we've heard today from Mr. Granzato and all we've heard from MAJ in their amicus brief are those stereotyped and conclusory statements about it's inherently adversarial, it's a de facto deposition, all of these doctors are bad and they're going to run roughshod over these plaintiffs. So the presumption in Michigan, the presumption from this court, is against unethical behavior by physicians. We presume that doctors are bound by the methodologies of their profession and by principles of professional integrity, and it's the plaintiff's burden to rebut that presumption. And that, I think, going to Justice Viviano's question about how the court rule should either be interpreted or restructured or something of that nature, if that's what this court decides to do, I think we have to bake that in to 2.311, particularly in this context of neuropsychological examinations.
Is that accounted for, you think, in the federal court rule that I read to the plaintiff's counsel?
I think we argue the federal court interpretation throughout our brief, throughout our supplemental brief, certainly the neurological.
Meaning that the general rule should be that videotaping is not allowed unless good cause is shown as to why it's needed in a particular case, which could then address what you've referenced, which is if the doctor in a particular case, for example, is a frequent flyer testifying for defendants or for this defendant or something along those lines.
I think that's a workable standard, but I would incorporate in your guidance that presumption from Feld and that presumption from Mucci that we assume that doctors are doing things ethically. And so unless there's that specific showing that I know some of the courts have discussed, those state courts, of this doctor has a history of being abusive in the examinations or being adversarial, unless you're coming forward with some specific evidence to rebut that presumption that doctors are going to be ethical, they're going to be fair, then that's part of the showing that has to be made.
Can we hold those two things to be true at the same time? I mean, this only arises in the context of litigation. By very nature, it's adversarial process, right? So we can recognize that, and then also recognize that doctors are able to, are presumed to be ethical and uphold their belief. But I don't think that means that we only adopt that and we ignore the fact or pretend that this isn't adversarial. I mean, it is brought up in order to defend against a cause of action, right? So, I mean,
I think, Justice Kavanaugh, the balance in this case, and this case is an interesting context. It's not just a, orthopedic examination or something. The neuropsychological, I think, builds a little bit of a higher hill of the burden, because in a different medical profession, video recording might not be a concern, but it is here. So I think when you're balancing and talking about this specific case, if you're balancing the question of whether you're going to be able to have this IME at all, because the plaintiff insists on recording it and your doctor says she won't have that and the test results won't be valid, I think that's a higher burden. And I think this court could work that into that, we've got to evaluate all of these things.
well, isn't that sort of taken care of through your protective order, the rules governing your protective order, right? I mean, this rule governs all physical and mental examinations. I don't think you're suggesting that we interpret a rule specifically with a particular type of examination in mind for a general court rule that applies to all types of examinations, right? Be it the ortho exam or something like that, but the particular concerns of the doctor or the particular exam or any number of other things are really sort of better evaluated under the protective order.
Yes, I agree that those concerns, that is the vehicle we use to raise those concerns. It is an adequate vehicle. All I'm saying is that I would not like to see something where you can come in with the evidence that we've had in this case from the plaintiff, which is just that statement that, IMEs are adversarial, and that's enough to get over the presumption that doctors are ethical. So I think it needs to be something more than just the general notion that IMEs are adversarial, and that's why we need to video record this to make sure the doctor isn't lying or the doctor isn't being abusive. That's where I was going with that. So I think all of the reasons, Justice Welch, why the neuropsychological community can't countenance video recording of these examinations is contained in the very comprehensive amicus brief that they filed. There's actual scientific evidence in there, so they've done studies of subjects being examined using third-party observation or video recording and not using third-party observation or video recording, and they've noted statistically significant different results. So we have actual science supporting that notion that unlike being here on camera, it makes a difference, and it actually, if you're going to go through the time and expense of having a neuropsychological examination only to have those results not be valid simply because the examination was video recorded or observed, then it's a colossal waste of time and money, and it's not the discovery process operating as it should. And what I found interesting was that the amicus brief mentioned a trial court opinion from Acosta County back in 2012, Long versus Chippewa Hills School District, and that's at the appendix pages 270 through 272 of the neuropsych amicus brief. And they looked at 2.311A in the context of a neuropsychological examination, and they found that the correct balance to strike, and this is maybe an example of how courts going forward can interpret the rule, it permitted the attorney to attend the clinical interview portion, but not the testing portion of the exam. And so when Mr. Gonzato was asking at the end of his argument, well, why can't we have the attorney, why can't we have someone record the interview portion of the exam? That's okay under some circumstances. So as far as that concern goes, it's been addressed and it's been accommodated. It's the testing itself, not the interview portion, that has to remain private from third-party observation. And so that proper balance was struck by the trial court in that opinion, and I think that does safeguard a defendant's right to have this neuropsychological examination and have it produce valid results. If there's no further questions, I'll conclude my arguments. Thank you.
Thank you very much. 36 seconds. Mr. Gonzato, do you want to use it?
Any questions?
Well played.
Well done.
I'll rest on what I've said. Thank you.
Thank you very much. The case will be submitted. That completes the case call.